Rules of Civil Procedure, Rule 8, Manner of Making Allegations in Pleadings. Section 1. In general, every pleading shall contain in a methodical and logical form a plain, concise, and direct statement of the ultimate facts, including the evidence on which the party pleadings relies for his claim or defense, as the case may be. If a cause of action or defense relied on is based on law, the pertinent provisions thereof and their applicability to him or her shall be clearly and concisely stated. Section 2. Alternative cause of action or defenses. A party may set forth two or more statements of a claim or defense alternatively or hypothetically, either in one cause of action or defense or in a separate causes of action or defenses. When two or more statements are made in the alternative and one of them, if made independently, would be sufficient, the pleading is not made insufficient by the insufficiency of one or more of the alternative statements. Section 3. Conditions precedent. In any pleading, a general averment of the performance or occurrence of all conditions precedent shall be sufficient. Section 4. Capacity. Facts showing the capacity of a party to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, or the legal existence of an organized association of persons that is made a party must be averred. A party desiring to raise an issue as the legal existence of any party or the capacity of any party to sue or be sued in any representative capacity shall do so by specific denial, which shall include such supporting particulars as are peculiarly within the pleader's knowledge. Section 5. Fraud, mistake, condition of the mind. In all averments of fraud or mistake, the circumstances constituting fraud or mistake must be stated with particularity. Malice, intent, knowledge, or other condition of the mind of a person may be averred generally. Section 6. Judgment. In pleading, a judgment or decision of a domestic or foreign court, judicial or quasi-judicial tribunal, or of a board or officer, it is sufficient to aver the judgment or decision without setting forth matter showing jurisdiction to render it. An authenticated copy of the judgment or decision shall be attached to the pleading. Section 7. Action or defense based on document. Whenever an action or defense is based upon a written instrument or document, the substance of such instrument or document shall be set forth in the pleading, and the original or a copy thereof shall be attached to the pleading as an exhibit, which shall be deemed to be a part of the pleading. Section 8. How to contest such document. When an action or defense is founded upon a written instrument or attached to the corresponding pleading as provided in the preceding section, the genuineness and due execution of the instrument shall be deemed admitted unless the adverse party under oath specifically denies them and set forth what he or she claims to be the facts, but the requirement of an oath does not apply when the adverse party does not appear to be a party to the instrument, or when compliance with an order for an inspection of the original instrument is refused. Section 9. Official document or act. In pleading, an official document or official act, it is sufficient to aver that the document was issued or the act was done in compliance with law. Section 10. Specific denial. A defendant must specify each material allegation of fact, the truth of which he or she does not admit, and whenever practicable, shall set forth the substance of the matters upon which he or she relies to support his or her denial. Where a defendant desires to deny only a part of an averment, he or she shall specify so much of it as is true. No. Where a defendant desires to deny only a part of an averment, he or she shall specify so much of it as is true and material, and shall deny only the remainder. Where a defendant is without knowledge or information sufficient to form a belief as to the truth of a material averment made in the complaint, he or she shall so state, as this shall have the effect of denial. Section 11. Allegations not specifically denied, deemed admitted. Material averments in a pleading asserting a claim or claims other than those as to the amount of unliquidated damages shall be deemed admitted when not specifically denied. Section 12. Affirmative defenses. A. A defendant shall raise his or her affirmative defenses in his or her answer, which shall be limited to the reason set forth under Section 5, letter B, Rule 6, and the following grounds. 1. That the court has no jurisdiction over the person of the defending party. 2. The venue is improperly laid. 3. That the plaintiff has no legal capacity to sue. 4. That the pleading asserting the claim states no cause of action. And 5. That a condition precedent for filing the claim has not been complied with. B. Failure to raise the affirmative defenses at the earliest opportunity shall constitute a waiver thereof. C. The court shall motu proprio resolve the above affirmative defenses within 30 calendar days from the filing of the answer. D. As to the other affirmative defenses under the first paragraph of Section 5, letter B, Rule 6, the court may conduct a summary hearing within 15 calendar days from the filing of the answer. Such affirmative defenses, if denied, shall not be the sufficient of a motion for reconsideration or petition for certiorari, prohibition, or mandamus, but may be among the matters to be raised on appeal after a judgment on the merits. Section 13. Striking out of pleading or matter contained therein. Upon motion made by a party before responding to a pleading, or if no responding pleading is permitted by these rules, upon motion made by a party within 20 calendar days after the service of the pleading upon him or her, or upon the court's own initiative at any time, the court may order any pleading to be stricken out, or that any sham or false, redundant, immaterial, impertinent, or scandalous matter be stricken out therefrom. Rule 9. Effect or failure to plead. Section 1. Defenses and objections not pleaded. Defenses and objections not pleaded either in a motion to dismiss or in the answer are deemed waived. However, when it appears from the pleadings or the evidence on record that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by a prior judgment or by statute of limitation, the court shall dismiss the claim. Section 2. Compulsory counterclaim or cross-claim not set up, barred. A compulsory A compulsory counterclaim or cross-claim not set up shall be barred. Section 3. Default declaration of. If the defending party fails to answer within the time allowed thereof, therefore, the court shall, upon motion of the claiming party with the notice of the defending party and proof of such failure, declare the defending party in default. Thereupon, the court shall proceed to render judgment granting the claimant such relief as his or her pleading may warrant, unless the court in its discretion requires the claimant to submit evidence. Such reception of evidence may be delegated to the clerk of court. A. Effect of order of default. A party in default shall be entitled to notice of subsequent proceedings but shall not take part in the trial. B. Relief from order of default. A party declared in default may at any time after notice thereof and before judgment file a motion under oath to set aside the order of default upon proper showing that his or her failure to answer was due to fraud, accident, mistake, or excusable negligence, and that he or she has a meritorious defense. In such case, the order of default may set aside on such terms and conditions as the judge may impose in the interest of justice. Section letter C. Effect of partial default. When a pleading asserting a claim states a common cause of action against several defending parties, some of whom answer and the others fails to do so, the court shall try the case against all upon the answers thus filed and render judgment upon the evidence presented. D. Extent of relief to be awarded. A judgment rendered against a party in default shall not exceed the amount or be different in kind from that prayed for, nor award unliquidated damages. C. Where no defaults allowed. If the defending party in an action for annulment or declaration of nullity of marriage or for legal separation fails to answer, the court shall order the Solicitor General or his or her deputized public prosecutor to investigate whether or not a collusion between the parties exists, and if there is no collusion, to intervene for the state in order to see to it that the evidence submitted is not fabricated. Rule 10. Amended and Supplemental Pleadings. Section 1. Amendment in general. Pleadings may be amended by adding or striking out an allegation or the name of any party, or by correcting a mistake in the name of a party, or a mistaken or inadequate allegation or description in any other respect, so that the actual merits of the controversy may speedily be determined without regard to technicalities and in the most expeditious and inexpensive manner. Section 2. Amendment as a matter of right. A party may amend his pleading once as a matter of right at any time before a responsive pleading is served, or in the case of a reply, at any time within 10 calendar days after it is served. Section 3. Amendment by leave of court. Except as provided in the next preceding section, substantial amendment may be made only upon leave of court, but such leave shall be refused if it appears to the court that the motion was made with intent to delay or confer jurisdiction of the court on the court, or the pleading stated no cause of action from the beginning which could be amended. Orders of the court upon the matters provided in this section shall be made upon motion filed in court, and after notice to the adverse party and an opportunity to be heard. Section 4. Formal amendments. A defect in the designation of the parties and other clearly clerical or typographical errors may be summarily corrected by the court at any stage of the action. its initiative or on motion, provided no prejudice is caused thereby to the adverse party. Section 5. No amendment necessary to conform or authorize presentation of evidence. When issues not raised by the pleadings are tried with the express or implied consent of the parties, they shall be treated in all respects as if they had been raised in the pleadings. All respect, no amendment of such pleadings deemed amended is necessary to cause them to conform to the evidence. Section 6. Supplemental pleadings. Upon motion of a party, the court may, upon reasonable notice and upon such terms as are just, permit him or her to serve a supplemental pleading setting forth transaction, occurrences or events which have happened since the date of the pleading sought to be supplemented. The adverse party may plead thereto within 10 calendar days from notice of the order admitting supplemental pleading. Section 7. Filing of amended pleadings. When any pleadings is amended, a new copy of the entire pleading incorporating the amendment, which shall be indicated by appropriate marks, shall be filed. Section 8. Effect of amended pleadings. An amended pleading supersedes the pleading that it amends. However, admission in superseded pleadings may be offered in evidence against the pleader, and claims or defenses alleged therein not incorporated in the amended pleading shall be deemed waived. Rule 11. When to file responsive pleading. Section 1. Answer to the complaint. The defendant shall file his or her answer to the complaint within 30 calendar days after service of summons, unless a different period is fixed by the court. Section 2. Answer of a defendant, foreign private juridical entity. Where a defendant is a foreign private juridical entity and service of summons is made on the government official designated by law to receive the same, the answer shall be filed within 60 calendar days after receipt of summons by such entity. Section 3. Answer to amended complaint. When the plaintiff files an amended complaint as a matter of right, the defendant shall answer the same within 30 calendar days after being served with a copy thereof. Where its filing is not a matter of right, the defendant shall answer the amended complaint within 15 calendar days from notice of the order admitting the same. An answer earlier filed may serve as the answer to the amended complaint if no answer is filed. This rule shall apply to the answer to an amended counterclaim, amended cross-claim, amended fourth party complaint, and amended complaint in intervention. Section 4. Answer to counterclaim or cross-claim. A counterclaim or cross-claim must be answered within 20 calendar days from service. Again, a counterclaim or cross-claim must be answered within 20 calendar days from service. Section 5. Answer to third-party complaint. The time to answer a third or fourth-party complaint shall be governed by the same rules as the answers to the complaint. Section 6. Reply. A reply, if allowed under Section 10, Rule 6 hereof, may be filed within 15 calendar days from receipt from service of the pleading responded to. Section 7. Answer to supplemental complaint. A supplemental complaint may be answered within 20 calendar days from notice of the order admitting the same, unless a different period is fixed by the court. The answer to the complaint shall serve as the answer to the supplemental complaint if no new or supplemental answer is filed. Section 8. Existing counterclaim or cross-claim. A compulsory counterclaim or a cross-claim that a defending party has at the time he or she files his or her answer shall be contained therein. Section 9. Counterclaim or cross-claim arising after answer. A counterclaim or cross-claim which either matured or was acquired by a party after serving his or her pleading may, with the permission of the court, be presented as a counterclaim or a cross-claim by supplemental pleading before judgment. Section 10. Omitted counterclaim or cross-claim. When a pleader fails to set up a counterclaim or a cross-claim through oversight, inadvertence, or excusable neglect, or when justice requires, he or she may, by leave of court, set up the counterclaim or cross-claim by amendment before judgment. Section 11. Extension of time to file answer. A defendant may, for meritorious reasons, be granted an additional period of not more than 30 calendar days to file an answer. A defendant is only allowed to file one motion for extension of time to file an answer. A motion for extension to file any pleading other than an answer is prohibited and considered a mere scrap of paper. The court, however, may allow any other pleading to be filed after the time fixed by these rules.